Welcome everyone to our webinar on COVID-19 workplace rules for small businesses and employees. I'm Alex Bruno. I will be your moderator for today's webinar. A bit of background on me. I'm a business attorney with my firm, Bruno Group Inc. here in Glendale. I also serve on the board of directors for the Glendale Chamber of Commerce. This webinar is being brought to you as a collaboration between the Armenian Bar Association and the Glendale Chamber of Commerce. Before I introduce our great speakers for today's webinar, I wanted to share a little bit about the Armenian Bar Association and the Glendale Chamber of Commerce. The Armenian Bar Association is a nonprofit organization that has been around for over 3 decades. The ABA opened up a pro bono clinic in 2018, and for the last 3 years has been providing legal services for residents and businesses in Glendale and throughout the surrounding areas. So if you have a need as a business owner or as a resident, please reach out to the Armenian Bar Association and find out more about their pro bono clinic. The Glendale Chamber of Commerce was established in 1910 and has served as the voice of business and has been involved in many of the major decisions that have made Glendale a great place to work and also to live. The Chamber's purpose is to advocate and create growth opportunities for Glendale business residents and visitors. Now, I would like to introduce our speakers for today. Shahane Martirosyan leads the Labor and Employment Department at Stephan Filip P.C. She represents individual employees in negotiations and litigation in a variety of employment matters, from sexual harassment, discrimination, retaliation, wrongful termination, family leave, and wage claims, among others. Ms. Martirosyan takes a client-centered approach to her practice and incorporates each client's unique circumstances and goals to tailor strategies that work best for each individual. Ms. Martirosyan is a passionate trial attorney who has been part of some very successful trials, including the 5th largest verdict in California, which was a whistleblower action against FedEx. Shahane, welcome. Armand Kizirian is a graduate of UCLA School of Law and UC Berkeley. Go Bears. Armand has exclusively represented employees and consumers throughout his time as a practicing attorney since he became licensed in 2013. Armand founded the Kizirian Law Firm in 2018. A zealous advocate, Armand is experienced in all facets of class action and individual litigation. Armand has represented clients in cases all over California, both in state and federal court. Whether in front of a trial court, an arbitrator, a court of appeal, Armand has the knowledge and the experience to get the desired results on behalf of his clients, which include pharmacists, truck drivers, nurses, waiters, technicians, store clerks, and many others, whether it's in the class action or in individual litigation. With that strong work ethic and creative thinking, Armand does his utmost to find success for his clients. Welcome, Armand. And before we get back to our speakers, a couple of ground rules I want to go over. One, our speakers have put together some top questions related to the topic of COVID-19, the workplace, and employees. So we'll be discussing these questions to start. But if you have questions yourself or want to pose a question to our panelists, please use the function, the Q&A function, through the Zoom platform and insert your question there. And we're going to try our best to get your questions answered during the second part of this webinar. If you're a lawyer and you're seeking MCLA credit, please email the Armenian Bar Association at info@armenianbar.org. We're also going to put that in the chat. So let's go ahead and get started. And we're going to begin with Shahane. Shahane, one of the questions that's come up all the time is, where are masks required indoors?
So masks are still mandated to be worn in all indoor public settings, regardless of vaccination status of the employee. So this would be places where the customers could go to, but also places where it's only the employees, such as the break room. You do not need to wear a mask in your own office. like me right now, I don't need to wear a mask because my door is closed and I'm in my office alone. However, there are stricter requirements if you are working in education, childcare, or healthcare. If you are working in those areas, and if you are a workplace in such as a school or a childcare place, a daycare, or a hospital, then everyone must be wearing a mask in all locations. This includes in a in your own office, even if the door is closed. Everybody is required to wear masks. And just a caveat, and I think Armand will probably touch on this also, this is the law as of October of 2021. So these laws on COVID-19 and the requirements do change quite frequently. So we want to emphasize that the laws are, whatever we're stating is just as to October of 2021.
That's correct. I mean, I agree with everything you said, Shahane. I would also just add that, you know, these are sort of minimum requirements that the state and county have imposed on businesses, but it's generally a good idea to encourage mask use. Both the CDC and the California Department of Public Health do recommend it when indoors, just because it's been shown to reduce the spread of COVID, and ultimately, from an employer perspective, you don't want your employees to get sick. You don't want customers to have, you know, outbreaks when they're visiting your business. So this should be seen as sort of a floor. Many businesses, I'm sure people have noticed, offer masks to customers if they've forgotten them. So it's so this should just be seen as a minimum requirement that the county and state are imposing in terms of mask use. But definitely businesses can go further than these minimums if they so desire.
Thank you, Shahane and Armand. And Armand, I'm gonna stick with you for a moment, because you mentioned about someone, you said an outbreak happening and people getting sick of COVID. So what happens if an employee tests positive for COVID? What can the what should the employer do?
So that's a good question, Alex. It's actually not just determined by what the employee's doctor says, but there are actually rules in place that an employer must follow once an employee tests positive, regardless of how the employee is feeling. So if there is a positive test for an employee, they need to stay away from the workplace for at least 10 days since the start of their symptoms. So if today is the first day that the employee feels sick and they don't get a positive test until, let's say, Saturday, that 10 days starts from today, the day that they first started feeling sick. Number two, they need to be fever-free for at least 24 hours before returning to the workplace. And this is without taking any medicine. So if you're taking Advil or Tylenol and you feel okay, that's not what the requirement is. Even without taking any medication, the employee has to feel fine, without a fever for at least 24 hours. And finally, they need to feel that their symptoms are improving. If they've been sick for several days and they kind of feel like it's not getting worse, it's not getting better, it's just kind of going on, in that circumstance, they should still stay away from the office, even if 10 days have gone by, even if they don't have a fever. Of course, a doctor might have an employee stay away from the workplace longer, but those are minimums that, according to the county health guidance, an employer has to follow if an employee tests positive.
I have a follow-up. So a coworker gets it. A coworker is in close contact with this person. What must they do?
So the good news is that if they're vaccinated, they don't need to do anything in terms of the coworker quarantine, right? If they are fully vaccinated, it doesn't make a difference in terms of the county COVID rules for them staying away. You know, they could have been working right next to them, you know, in one cubicle over. If they're vaccinated, they're fine. They can come back to work the next day. They never need to stay away. If they're unvaccinated, however, the unvaccinated employee who is in close contact with someone who has COVID must quarantine for at least 10 days. If they don't develop any COVID symptoms, though, after 7 days, and they take a COVID test at least 5 days into the quarantine, or I should say, if the COVID test is taken at least 5 days into the quarantine and it comes back negative, they can cut that quarantine period down to 7 days instead of 10 days. But again, that's only if the employee isn't vaccinated. If they are vaccinated, there are no longer any legal quarantine requirements for people who are in close contact with someone who tests positive.
Great, thank you for that. And again, to reiterate what Shahane brought up earlier, these rules keep changing. So you always got to keep up to date, and we're just trying to focus on what the rules we have right as of right now. And staying with the topic of an employee testing positive, Shahane, so are there any details that an employer can give about that specific employee?
So none of the emergency orders put in place right now by the government talk about releasing employee-specific information to coworkers. However, at the same time, you're still supposed to advise your workforce about a potential exposure in the workplace. So that puts employers in a really tough situation because you are not allowed to, as an employer, to release any medical information about any of your employees to the rest of the workforce. So even when we're talking about COVID rules, we still have to keep in mind that all the rest of the federal and state and county rules still apply. So HIPAA is still in place. What this means is you, as an employer, want to document that you have advised the workforce of what to do once there's an exposure, while keeping the individual's identity and symptoms and anything medical related private. So we would probably recommend doing something along the lines of doing an email to the workforce saying there was a potential exposure if you are, and then going through the rules that Armand just went through. If you're not vaccinated, you should stay home if you were working around this cubicle. Obviously, employees are probably going to guesstimate who the person with COVID is, but you as an employer are not allowed to say anything about it or put anything like that in writing. For instance, you can't say Armand tested positive for COVID and he came to work, so anyone working around Armand should start getting tested. You can't say anything like that. You have to keep it very confidential, while at the same time, it's a balancing act, while at the same time trying to make sure that the rest of your workforce, if they are not vaccinated, proceeds to get tested or quarantines themselves according to the rules at the time.
Yeah, I think Shahane is exactly spot on. And I mean, I think this sometimes could be the most unusual aspect for this for smaller employers, where it's pretty clear if someone's not at the workplace and an email like that goes out, who it is that tested positive. But still, there are pretty strict employee privacy laws that have not been relaxed or waived because of COVID. And even if the employees should figure it out, an employer should not think, oh well, everyone's going to know, so why bother? You might still give out more detail than employees could figure out. Maybe the employee, doesn't want people contacting them about it, doesn't want, day-to-day updates of how their COVID is going. So I think that's an important facet there, that if someone is, in a supervisory or managerial position and everyone knows, who the employee is who got COVID, it's just something that the employer should not be talking about.
Great, thank you, Shahane. Thank you, Armand. As a reminder to our audience, if you have any questions, please go ahead and submit it using the Q&A tool. We'll be responding to those questions if they apply within, in the course of this webinar, or at the end when we have a little bit of Q&A. And staying with you for a second, Armand, if an employee has COVID, how much time off are they entitled?
Can you hear me, Alex? You cut out there for a second. Can you hear me, Shahane?
I can hear you. I think Alex's camera may have frozen.
Okay, well, I'll go ahead and start answering that question, and hopefully Alex can hear us and jump back in. So essentially, earlier in the pandemic, actually up until about a month ago, the state did enact special rules to give people extra time off if they tested positive for COVID, or were someone who was in close contact to someone who tested positive for COVID. But as of the start of October, all of those rules have gone away. So as of today, if someone tests positive for COVID, there are no special rules in place that give them any extra time off. Essentially, what that means is that just the baseline rules that have existed now in California for a few years would apply. And the minimum requirement for most employers in California is that they need to give their employees 3 paid days off a year, at least, for sick days. Now that seems very limiting, and in a sense it is. I mean, personally speaking, as an employment lawyer, I would hope most businesses that have the capacity to give employees more time off if they're sick would. But in the event of COVID, if an employee encounters a situation where the employer is really not being flexible for whatever reason, there is a federal law, the Family Medical Leave Act, that does give an employee the ability to take job protected leave in the event they're sick. Now, typically, FMLA leave is used for something more like, for example, if someone unfortunately had a cancer diagnosis, and they have to be out for a few months to do radiation or chemotherapy. That's usually where FMLA leave comes in. But if for some reason an employee can't get the time off, or an employer is wondering whether they have to give an employee time off to deal with a COVID-19 diagnosis and just going through that illness, technically the employee can request a leave through FMLA. I should say though, FMLA only gives you job protected leave, meaning that if you're on FMLA leave, you can't be fired by your employer. It does not, however, entitle you to get paid from your employer while you're on leave. That being said, typically if someone is on FMLA leave, they can often get state disability insurance payments. And in fact, California's state disability insurance program does cover COVID-19 illness. So if someone has a really bad bout of COVID, they're out for 3 weeks. Technically, the employee has to give, if it's requested, and the employee should know they're entitled to it, they can get time off, job protected time off through FMLA, and they can get at least partial compensation for time that they're missing work through California's disability insurance plan. And both of these things, FMLA and disability insurance, could come in after the employee exhausts their normal paid time off, paid sick day benefit that the employer has to give, which in California is at least 3 days for a full-time employee.
Now,
Locally, go ahead.
Yeah, I was going to say, I know we're in Glendale and we're talking about California is 3 days, but are there other cities, such as the big one right next door to us, city of Los Angeles, that requires more than 3 days for paid sick leave? Shahane.
That's what I was going to say. It is 5 days for city of Los Angeles, and the city of Santa Monica has separate sick days, and various cities do have a number of sick days. It's just the minimum requirement is 3 sick days or 24 hours off for each employee. Just a practical matter as an employer, it is I think people are advising, attorneys are advising the employers to simply pay their employees whenever they are out because of COVID, or if they need to take time off because they need to be tested because they were exposed. It is highly recommended that you simply pay the employee for the 2 hours they need to take off to get a COVID test, or a day that they need to take off to make sure that they're negative. Because again, given the job market right now, I think most employers are trying to keep their employees, and this is one good way to keep your employees continuing to work for you. And just one note for the state disability insurance, a timely claim is a claim filed within 41 days, just to add that little notation. In general, all of the FEHA, the Fair Employment Housing Act laws still apply whenever an employee is asking for time off for COVID. And if they do take time off because of COVID, because there's complication, they have a hospital visit, anything like that, all of the rest of the California employment laws still apply. So we can't forget about those laws when we're just addressing COVID. I keep reiterating that because I think it's very important to keep in mind that if one of your employees needs to take a time off or needs to work from home or anything like that, and you can accommodate it, you should do that under the FEHA, the Fair Employment Housing Act in California, that is still in full effect with or without COVID.
Thank you. And I'm just scanning the questions to see if we had anything. There was a question about maternity, but I might ask for a clarification on it because someone's on leave for 4 months for maternity. I don't know. I was supposed to say if they come back from their leave, what you both were talking about in terms of the time that they can take off through FMLA and other things, they can still do it. So
the Fair Employment Housing Act provides for a reasonable amount of time for leave. If you are disabled or if you have a doctor's note that puts you out because of some sort of a disability, and COVID is not always a disability, but it can be. So if you are out or you need time off because of that, you can still take it if you meet certain requirements, even if you've exhausted it through maternity leave. So for instance, if you took maternity leave because you had a baby and then you come back to work, but then you were exposed to COVID, or you get COVID, you can still take time off to job protected time off from work.
I think we got a clarification, but we'll come back to you. It doesn't say your name, but we'll come back to you asking about the person who's in maternity and they want to come back and they're not vaccinated. But we'll come back to that question because that's going to come up in another situation for us. But Shahane, while we're still chatting a little bit, just go back to the basics. The rules for social distancing. What do they look like right now?
There are no more rules in California or in Los Angeles County for social distancing. However, the Centers for Disease Control and Prevention still recommend staying at least 6 feet away from other individuals. That's the rule right now. It could change tomorrow, I suppose, but that's the current rule.
Thank you for that. And then similar question that's going to be kind of related to this, Armand, is, are there any indoor capacity limits in place?
They do not have, the CDC and other government agencies at this point do not have any indoor capacity limit that applies. I know in the past, restaurants were sometimes limited to a quarter to half capacity. There is no such limitation in place. There are, however, recommendations. And the recommendations are that as much as possible, capacity should be limited so that social distancing can be maintained. That's not always practical, but to the extent, a business can extend a customer line a little bit out the front doors, keep the doors and windows open to increase ventilation. Those are strongly encouraged by the CDC. But the county, the state, they don't have any limitations anymore in terms of indoor capacity. So, while it probably wouldn't be a very wise thing, technically, if it's a bar or something, it could be just as crammed at this point as it was pre-COVID, and it's probably not a smart move health-wise, but it is not illegal anymore in Los Angeles County.
Thank you, Armand. And Shahane, who is required to, by the law, as we're talking about right now, who's required to get vaccinated?
California law requires healthcare workers and school workers to be vaccinated. There are some exceptions, but California law itself requires just the healthcare workers and the school workers. If you want to opt out of being vaccinated, there are only 2 exceptions, and one of the exceptions is the religious belief. The second exception is if you are there's a medically qualified reason. So if your doctor provides a doctor's note that you can then provide to your employer, that's a school or a healthcare provider, which specifically states that you cannot get vaccinated because of health concerns. I just want to address the religious exception really quickly in detail, and then I'll address the medical reason. So the religious exception, it's very important to keep in mind that this has to be a sincerely held religious belief, not just because you believe your religion does not require you to get vaccinated. So there are only maybe 0.1% of religions qualify for this exception. Most religious leaders have made statements, have either not made any statements regarding vaccination, or have they made statements for vaccination. So you can't just say, I believe my religion exempts me. You actually have to have a sincerely held religious belief, practice, or observance, and your employer can ask you about it. So you can't simply just say, my religion doesn't let me get vaccinated. That doesn't qualify for the religious exemption. For the medical reasons, again, a qualified medical professional is supposed to give the employee a documentation that this particular employee cannot be vaccinated with the COVID-19 vaccine. And then that can be submitted to your employer if your employer is a healthcare provider or a school in the state of California.
And I would just add to what Shahane has said. You know, in terms of the qualified medical reason, it's really important to get a doctor's note if you feel you qualify. It's not enough, you know, for the employee to assert that they qualify, even if they have a specific medical reason that they think might interfere with it. This isn't, you know, exactly for vaccination, but let's say for face masks. I had a question come up the other day where the employee, they know they have asthma. They thought they didn't have to wear a face mask, and they just, you know, told the employer, I have asthma. And they got in trouble for work because of it, because they didn't have a doctor's note. So the same sort of thing applies here, where, you know, even if you feel like, you know, it's an obvious thing, you have this condition, you know, or maybe you're undergoing treatment for cancer, something like that, you clearly qualify, you still need to actually get that in writing from a doctor or the relevant medical professional. If the employee self-diagnoses, but the employer does not have to honor that. And, you know, I would also just emphasize what Shahane said with the religious exemption, that it is, you know, the state put that into effect to comply essentially with, you know, with the Constitution's requirements on freedom of religious practice. But, you know, in practice, very, very few people qualify for it. Generally, the people who've had the most success with that are if they're part of their religion is minimizes any kind of medical treatment. At least I personally don't know any that specifically target vaccines. So, I mean, you know, for the most, I guess, widespread religions in California, you know, like various branches of Christianity, for most people, they would not qualify for the religious exemption. You know, even if they say, well, I really believe it goes against my religion, it has to have some deeper root. It has to somehow be rooted in the doctrine or the dogma of a religion. And as Shahane said, a lot of religious leaders have either said nothing about vaccines or have encouraged, you know, their congregants to get vaccinated. And in those circumstances, an individual person who's part of that religion would almost certainly not qualify.
And because the event is sponsored in part by the Armenian Bar Association, we are not aware of the Armenian churches making any statements regarding really any medical treatment, but they definitely have not made, we're not aware of them making any statements against vaccination, a COVID vaccine.
Thank you for that, Shahane. And our next question, actually, it's going to blend with some of the other questions that are being posed in the Q&A box, and it has to do with and I'm gonna start with you, Armand. It has to deal with mandating a vaccine on someone, right? Can small businesses require employees to get vaccinated?
Yes. In fact, California has been encouraging employers to set up vaccine requirements. So with the previous question, Shahane covered which type of employees have to get vaccinated, right? And she essentially gave those two categories as healthcare workers and school workers. Other employers are not required to have their employees get vaccinated, but the state does certainly encourage it. And so the obvious kind of follow-up that flows from that is, well, what sort of policy should an employer put in place if they want to get their employees vaccinated. And probably the safest policy for an employer would be to do what the state is requiring of educators and healthcare employees, which essentially means that an employer, if they wanted to enact such a policy, should require everyone to get vaccinated unless they have a medical exemption or a religious exemption. Part of the difficulty here is that because this is all sort of so new, and some people are filing lawsuits to challenge these vaccine mandates that employers are increasingly requiring, it's not so clear where things will stand, right? I mean, the employer doesn't want to be in a position of having enacted some policy only for some court 6 months from now to say, hey, any employer that did that had an illegal policy in place, right? So the safest thing, I believe, is to basically just follow the state's lead in what they have required for healthcare workers and for educators, and to not come up with more stringent requirements, you know, for example, not recognizing a religious exemption, because that makes it more likely that the employer could, you know, potentially get in trouble, end up on the wrong side of the law, while at the same time giving a means for employees who legitimately have a reason to opt out, whether it's a medical reason or a religious reason, to do so.
And just to add, based on the calls that our office has been receiving, when you are as an employer, if you're implementing the vaccination mandate within your business, in addition to what Armand just stated as a recommendation, I would say do it to all the employees at the same time. So via email potentially would be the best way, and ensure that your policy is directed to all employees. Do not go up to one group of employees and tell them they need to be vaccinated. Don't go up to one individual person. Just do it, you know, in unison, just to everybody. Address the actual document itself should say to all employees. That's what I would recommend based on the calls that my office has been receiving from employees.
And then to follow up on these on what you all presented so far in this question, and just kind of I'm paraphrasing a little bit the questions here that are in the chat, is, you know, there's a vaccination policy by an employer. Some of the existing employees opted out for valid medical reasons. Is it okay for an employer to require new hires as a condition of employment to be vaccinated?
Yes, I think that would be a reasonable policy to require new hires to undergo the same requirements about getting vaccinated as current employees. If an employer though was asking about vaccination status, they should make sure though that the employee has a way of communicating if they have a medical health exemption or a religious exemption. The employer shouldn't have it where, you know, yes, no, are you vaccinated? You're not, goodbye. There still needs to be an ability for an applicant to show that they might qualify under one of the exemptions that the employer might have for its current employees.
Great. And so the topic of leave, so that was the kind of question that came back. So someone was on leave for whatever reason. In this particular example, it was for family leave, and they want to come back, but they're not vaccinated. how should the employer handle that?
Or if the employer has a policy that all employees need to be vaccinated, absent those two exceptions, then the employee is supposed to be vaccinated before they return back to work. So the communication should be from the employer to the employee that we have this new policy in place. It's consistent with the California law on vaccination, mandated on healthcare workers and school employees. So you should be vaccinated before you come back, unless you qualify for an exemption, and then you set forth the exemption. And everyone should just communicate. I think that's, the biggest advice on the planet for employees and employers is that people should just communicate with one another just to make sure everyone's on the same page.
Okay. We're starting, there's some questions starting to come in now. So I'm going to keep, it's actually, we're still within the realm here of our our question about requiring employees to get vaccinated. There's been a question that's expanded to volunteers and interns at that workplace. Can the same policies apply to them?
Yes.
Yeah, absolutely. There is nothing special about interns or volunteers that could have them legally opt out of a vaccine mandate that the employer is otherwise requiring for its employees.
All right, now we're taking it a step forward before employment. So there's a question here about, can an interviewee, I guess there's an interviewee, can an interviewee sue if vaccination is a condition before an interview is set up?
I think we need more information on that. Unless Armand, you want to tackle that.
I think what Shahane just said a moment ago, the key is communication. So if the employer asks, hey, are you vaccinated? If so, let's set up an interview. I don't think that's a lawsuit of like, hey, they didn't say what if I have an exemption. So I think the key there, based on what Sean has said earlier, is you really have to communicate with the employee to see, or I'm sorry, with the employer, both parties together, to see what it is that the company is requiring. I don't think you could have it where it's like a gotcha kind of scenario just based off of one communication. So I would strongly agree with what Shahane has said, that you should communicate with the employer.
And we're not like, it should always be last resort,
right,
for everything.
Yeah, thank you for that. Thank you for that. And by the way, folks, these are very highly skilled professionals who advocate on behalf of employees when the employees have been wrongful action has been done against them. So you're hearing it from the employee side as opposed to the employer's attorneys. So yeah, it seems like this is not like a ban the box scenario where there's certain questions you can't ask as a screening tool. I
would say the employer should not have that as a screening tool. I would say that the employer's rules should state, once you are hired, you want to begin working at this place of employment, one of our rules is that the employees are vaccinated absent specific exceptions. That should be the rule, because if the person is not vaccinated, they might get vaccinated to begin their employment. So I think that's how I would leave it. I would not directly ask during an interview, are you vaccinated? I would also not recommend that employee to proceed to sue after either. So it's good to cooperate and communicate. It's a new area of law. It's a new area of just living. So it's good for everybody to communicate with one another rather than jump the gun and just sue each other for an area of law that's still developing. It's changing every single day.
So thank you. And so another question, a little bit still related to our an employer requiring, vaccination. What is the proof that they're allowed to ask for, like from an employee? Is it just like the kind of cards that the people like who have gotten vaccinated have, or is there anything more special to get to that?
No, I think that card is sufficient and probably the most universally recognized proof of vaccination.
Yeah, and I think as also just as a head, I know there's an electronic record now that the California Department of Public Health also does, so that's something also to for people to look into. Okay, we got some pretty fact-specific questions here, so I'm gonna kind of skip through these a little bit because these are like for all us lawyers in there, these are like hypotheticals that we can spin a lot, but we still have some more like value that we want to give to you. And before we get to some of these other follow-up questions, what we want to do is we have a poll. The Armenian Bar Association has a poll that we'd like you to take. And so we're going to take a moment here, take a break before we get into these other questions. And the poll is going to pop up, and please participate. It's very important that we get your feedback. It's going to be helpful for us. And there it is. So it's 3 questions. So please go ahead and do that for a moment. We'll give it a moment. Okay, we're gonna keep the poll up for a little bit. Actually, yeah, it might be up for a little bit. So get your choices in before it goes away. But we're gonna get back to. I want to get back to something before we run out of time, because we're all mindful of your time. We know that some of you have taken the lunch hour. If you take a lunch hour for this, so I want to get into a little bit about what are best practices. So we're kind of going to open this up for both Shahane and Armand, talking about best practices for both employers and employees. And you both have reiterated, and I agree with it, in terms of communication is the key. Be open on it. It's very foreign to all of us. There's nothing black and white. And sometimes things are beyond our control, whether it's the pandemic, whether it's the government saying, hey, guess what? We're changing it again. We got to be very flexible with it. But what other best practices can we do for employers and employees?
So I think a very good one that should sort of inform this whole background to reopening with COVID is that employers and employees should be very, very flexible with each other, to the maximum extent possible. If an employee isn't feeling good, I think, particularly now, in this COVID world that we're in, the employer should be generous in letting them take time off. But on the flip side of that, if someone comes to the office and they clearly seem to have some sort of cold symptom, I think the employer should step up and send that person home. I think that's particularly true for the sake of coworkers, right, who don't have that ability to tell a colleague, hey, you're not feeling well, go home, take the day off. So I think that would help put employees at ease if they don't feel like they have to be policing their coworkers. Ideally the coworker wouldn't show up sick. Ideally the employer would be generous with giving them time off, but in the event an employee comes because they don't seem to care or don't think COVID's a big thing, to step up and send that an employee home. I mean, a lot of what we discussed this afternoon is just baseline minimum requirements that the state and county governments impose on employers and employees. But I strongly feel that common sense should be a guide to this, and where appropriate, an employer and an employee should go further than what the law requires as a bare minimum.
I like practical rules and practical ways of doing everything. I would say if you're an employer, have a bunch of hand sanitizers all over the office, put some masks all over the office, HEPA air purifiers, put them. They're very good. Healthcare workers use them. Put them all over the office. Put signs in the office to encourage employees to sanitize their hands, or wear a mask, and just be mindful of one another. I think it's always good to work in this together, because it's going to pass. We will have pills for this. Everything's going to be okay. This is just something we're dealing with right now, and I think it's good to be mindful of one another. And just one more practical advice I would give: if someone tests positive in your office and you're an employer, maybe sanitize that area or have it disinfected once they, at night, and put a HEPA air purifier nearby. I think it's good to be just prepared. That's it. That's pretty much it.
And something else to add, I like that advice of practical advice or practical steps that can be taken. So a lot of people who get COVID either don't have severe symptoms or are asymptomatic, right? But the law requires that they can't show up to work if they just tested positive for COVID yesterday. So, to the extent possible, just because an employee tests positive for COVID doesn't mean they need to stop working if you can have them work from home. For a lot of jobs, it works, quite well. You don't have to be there physically in person. I will say, as a caveat though, if an employee says that I tested positive or I'm feeling sick, the employer shouldn't say, oh, okay, great, well, you're working from home then, right? Like it should still, to the extent reasonable, be the employee's choice, whether they want to work or whether they just can't work today because they're feeling sick. But if there is a will for the employee to work, and the employer is okay with it, then even someone who's tested positive doesn't need to stop working if they can work from home.
Thank you for that. I want to, before we have a little bit of time left, I want to follow up on a couple questions. I'm trying to get through some of the questions, so we apologize in advance again. We expected to get a lot more questions than we were able to answer, unfortunately, but we'll try to get, feel free to reach out to us separately or reach out to the Bar Association if you have a certain specific question. But the question came up in the chat about having a questionnaire for patients and customers. And I'm thinking they're talking about like when people were screening early on in this time period. I think that's the actual question. Is there, just to clarify, there's not any kind of mandate for that.
Is this at the healthcare or facility or?
Good question. And I guess the follow-up question is it about vaccination? Are you vaccinated or not?
What's the question?
Hold on. So the specific question was, do we still have to do questionnaire for our patients or customers? And I'm assuming they're hold on. Nope. I was assuming they're asking for like a screen before someone comes into their facility.
So I would say that I think it would probably be okay to have a questionnaire like that. And again, let's assume it's not a healthcare facility or education facility where it's more mandatory, right? Let's, I suppose, make it a more generalized question where some business just wants to have that in place. I think it would be okay to have that questionnaire, but again, the baseline rules would still sort of apply, where you would want to probably have a policy that follows the state's lead in what they've done in terms of having the exemption for medical reasons or religious reasons. Because if someone has some sort of condition where their doctors say they cannot get vaccinated, and the company is barring customers who are vaccinated from coming into the store, you could potentially have an American with Disabilities Act issue, right? Because someone has a disability, they cannot get vaccinated, and you're saying you're not vaccinated, you can't come in, end of story. So I think questionnaires are okay, but if you are going to do a questionnaire, you still have to follow all the other generally applicable laws out there in terms of giving access to your business to people with disabilities. So I would be more careful, I suppose, though it's probably allowed. I would be more careful about having, you know, some sort of questionnaire and allowing people to come in or not, you know, just based off that without any kind of ability to interact with the company.
And just to add, if you are going to do a questionnaire or a temperature check at the door of your establishment or the entrance of the establishment, if you do record those, you should still be complying with HIPAA. That's why a lot of places, when they do the temperature check or ask you the questionnaire, they do not write it down, because if you do not write it down, then you do not have a medical record. But if you do write it down, then you have a medical record, and you would need to start complying with HIPAA privacy rights on how you keep those records.
Great. Thank you for that, Shahane. Thank you, Shahane. Thank you, Armand. I am going to stop this presentation because we're at 1 o'clock and I don't want to be mindful of people's time. So
thank you, Alex.
Thank you, Alex.
I think that's
everyone.
it. That's it for today. And please, again, follow up if you're a member of the bar. Follow up with the Armenian Bar Association for your MCLE credits. And we hope everyone stays safe, and we'll see you at the next one.
Thank you, everyone.
Bye-bye.
Bye, everyone.